Well, good evening, everybody, and welcome to the Bonavera Institute and the Program for the Foundations of Constitutional Law and Governance Conference on the Law and Politics in Three Courts. We're starting tonight with a really intriguing conversation, or I hope it's going to be an intriguing conversation, exploring some of the difficult questions that arise about thinking about a particular continent and jurisprudence. Now, of course, very often we think about that particular continent being Europe or North America, but I'm really delighted that tonight we're going to be thinking about these questions from the perspective of Africa, and I think we're very fortunate to have a really interesting panel to discuss that. I'm not going to introduce them because I'm going to leave that to AK, but I just wanted to say how delighted we are to be partnering with the program on this event tonight and tomorrow. We're looking forward to really interesting conversations. And to welcome you all here on this kind of rather cold and damp evening, and delighted that you've all been able to make it. And I hope that we'll see a lot of you here again tomorrow. Thank you. Okay, I'm going to hand over to you.
Well, thanks again to Kate, to the Bonavero, to the Program for the Foundations of Law and Constitutional Government, and also to the JDG, the Jurisprudence Discussion Group, for their help in making this landmark event possible. I'm delighted to announce that we have with us three very distinguished speakers. Immediately to my left is Dr. John Ambani, who's a senior lecturer at Strathmore Law School in Kenya. He's an African governance scholar and the editor-in-chief of the Strathmore Law Journal, which is the house law journal of the Strathmore University. In the middle here, we have Khomotso Moshikaro, who has been a clerk at the South African Constitutional Court. He was a lecturer in private law at the University of Cape Town, and amongst other things, he has taught constitutional law and a course on social justice and the Constitution. He's presently writing his PhD at the University of Cambridge, and he's writing on the morality of the state labeling criminal offenders. Finally, to my left, at the far left, we have Joel Modiri, who is a senior lecturer in the Department of Jurisprudence at the University of Pretoria in South Africa. His research interests are in the fields of social theory and legal philosophy. And just to note, in regards to a housekeeping matter, if the fire alarm goes, you should congregate in the quad, and fire exits are behind and here to my left. Okay, so we'll begin in the best way that jurisprudence can, by problematizing the name of our conference. So I'll ask Khomotso to start with our question of whether African jurisprudence is an appropriate denominator for the field of study that we're talking about.
Oh, right. Is this on? Okay, great. So welcome, everyone. Really appreciate everyone coming and braving the cold to join us. So I thought to tackle the question by mutual agreement by defining some conceptual terms, as is traditional for anyone trained in Oxford. And so I think the first point of departure would be to make a distinction between African jurisprudence versus jurisprudence in Africa, or teaching or studying jurisprudence whilst being in Africa. The reason for that would be we could define African jurisprudence as a particular normative, value-based approach anchored in what one can loosely call an African tradition, which would be the equivalent of any other particular sort of geographical and cultural group with particular emphasis on certain questions in philosophy, and particularly the philosophy of law, that make it unique from other traditions, right? Much like we would have the distinction between analytical and continental, European and Chinese philosophy, or whatever it might be. Then the second alternative would be doing jurisprudence in Africa, which would be something like studying jurisprudence, but not necessarily from an African perspective or following that particular African tradition, but having good luck of just being located in Africa. So it would be, for instance, a jurisprudence program comprising entirely of Hart, Dworkin, Raz, etc., just taught in Kenya, right? with no particular sort of emphasis of unique philosophical or legal problems that might be attendant on that particular tradition or group, that is African jurisprudence itself. So I think that's an important point of departure, and you'll see common themes probably emerge about the tension between these two questions as we tackle the rest of the questions. I know certainly Joel has his views on this problem, and I have mine as well. And so in that vein, I think I might as well attack the problem. So the first thing would be whether or not this is an important distinction to make, and what obligations are attendant on scholars working in African jurisprudence to keep this in mind. By this, I think my view anyway would be to make the distinction between the priority of certain questions anchored in the African tradition versus ideological conformity with a particular position considered to be distinctly or uniquely African. And I will explain the difference by means of an example. So for instance, it's easy enough to understand that in African jurisprudence, perhaps certain questions of justice, namely perhaps corrective justice in the decolonial context, might take priority. However, it's a totally different thing to say that there are certain right answers to those particular problems anchored from one particular kind of political position, i.e., that the correct view of corrective justice problems relating to the challenges that colonialism has posed for African societies must be answered anchored from a particular political position, right? Or a moral position. So I think one admitting that African jurisprudence is probably more correctly, in my view, described as the priority of those questions, irrespective almost of the content in terms of substantive answers to those problems. So I'll use a familiar term here and believe that a content-independent approach ought to be applied to defining African jurisprudence in those terms, i.e., certain questions have priority, however, we are suitably skeptical about set answers to those questions and instead argue them out, as opposed to assuming certain conclusions and ex post facto reasoning our way to it, which is another controversial point of view, I suppose, for a legal philosopher to say is even possible, but I certainly think that it is. And so that will be my opening salvo about the content independence of prioritizing certain questions in African jurisprudence, giving it its definitional criteria. Or certainly, that is the position that I would hold to. And we will hopefully explore some of that when we get to questions of themes, etc., where maybe I might be able to develop my view about what are distinctly, uniquely African priorities in terms of moral or conceptual questions related to the study of jurisprudence. Yeah.
Thank you, Khomotso. Joel, can you give your perspective on the question?
Yes, thank you and good evening. So much of the answer to the question turns absolutely on what one thinks of as law in the first instance, and then secondly, what one thinks of as jurisprudence. And it will have something to do with the continental analytic divide, which I'll say a bit about shortly. But perhaps I'll start just by continuing with Khomotso's distinction between jurisprudence in Africa versus African jurisprudence and being sure not to conflate the two. Jurisprudence in Africa simply means the practice of Western jurisprudence in Africa. And so if one looks at many recent books on Africa and philosophy and jurisprudence, you'll see phrases like philosophy for Africa, or you'll see phrases like jurisprudence in an African context. The assumption being that Africa has no jurisprudence of its own or no philosophy of its own, but the philosophy is to be exported in, transplanted, and then, of course, applied for those people. So it's crucial, I would say, that the scholarship and teaching of jurisprudence in South Africa has essentially been, for many years, a Eurocentric enterprise. And not simply a Eurocentric enterprise, but also a demographically and conceptually wide enterprise in South Africa. That shouldn't be a surprise. It is an outgrowth of the country's history. So a lot of what we might think about in terms of jurisprudence has to do with the kind of what I'll call the epistemic arrangements created by a multi-century conquest and subjugation of the indigenous people in South Africa. So what we've ended up with has been mostly jurisprudence in Africa, not yet or not sufficiently an African jurisprudence. And I'll say a little bit about what an African jurisprudence is, but I do want to say that the material basis for the practice of jurisprudence today in South Africa and other parts of the world is colonialism. I've made that point. But the first has to do with the imposition of colonial legal systems, which forced you and forces us even still today to have to grapple with the questions of Western jurisprudence because you're dealing with a society that has been forcibly westernized over a long period of time. And the function in this instance of colonial legal systems, as we know, was to justify and rationalize, among other things, dispossession, conquest, in South Africa also kind of the cultural dominance of the white settler population, which is something that continues. The second material basis for jurisprudence in Africa, for the practice of jurisprudence jurisprudence in Africa, is simply epistemic racism, the assumption in this instance that the African cannot think, or that the African has been unable to develop a thought of their own that is original. That is to say that that Africans are in the position of having to mimic knowledges and discourses, and importantly, cognitive paradigms that come from elsewhere, and that elsewhere being because of colonization. So one of the reasons we still find South African curricula dominated by Western theory, and not just the sort of, let's call it the conservative or classical Western legal theory, but also the critical Western legal theory from Marx right up until CLS in the 70s, is the inescapable assumption that Western civilization is the superior epistemic form. And that's something a lot of us, or a new generation of scholars in South Africa, has been challenging very seriously by drawing on African-centered thinking, both on the continent and in the diaspora, as a way of challenging it. So the first point I'd make is there's a material basis to why jurisprudence in Africa is practiced the way it is, and the reason why there's so much strangeness. I mean, sometimes people talk about African jurisprudence like it's some kind of unicorn, but the reason is because of the destruction of the material conditions of African people. The third material basis for the practice of jurisprudence in Africa is the dismissal, but even the subjugation of African indigenous knowledges, indigenous sovereignties, and importantly, indigenous jurisprudences. So I'm working from the assumption that jurisprudence, like philosophy, has specific cultural and philosophical assumptions tied to place. There are no accounts from nowhere, at least that's sort of what I think. And what happened was that indigenous laws increasingly became constrained by the edifice of colonial power. Those three things, racism, conquest, and the subjugation of indigenous law, have essentially forced much of the scholarship to be westernized or Western in tone and form. African jurisprudence, on the other hand, is a completely different thing, and Khomotso has drawn out the distinction that it comes out of the history, the culture, and experience of African people. It is in no way monolithic, it is in no way without debate, tension, and difference, but what it is that its starting point, its roots, its questions and paradigms, its fundamental assumptions about the human and about law and about the political and about social organization come out of the African experience and are not transplanted or imported from elsewhere. I hope that captures what I'm trying to say about the need to account for a colonial history that has shaped legal knowledge in Africa and in Africa's relationship with the rest of the world. I'll leave it there.
Thanks. And Ambani?
Okay. Thank you. I'm happy to be here with you. Allow me to make a confession, actually, that the sins that have been described, I've committed all of them before as a teacher of jurisprudence in my universities where I taught it. For instance, I remember in the earlier years of teaching jurisprudence having a course outline that is entirely Western. So you're teaching Hart, you're teaching Fuller, you're teaching Dawkins, you're teaching Marx, and no African name. And I remember that once a student asked me, do we have Africans that have written about jurisprudence? Do Africans think about these things at all? So I began to introduce some Africans in the course outline. For instance, one of my favorite, Mandela's Rivonia trial speech, for example. And then I began to Africanize it. But as I did, I still found that it was even a greater ill to do that, because it's one thing to have Western scholars on your course outline. It's another to have African scholars who are simply writing Western ideas, you see? So the only difference is the skin color of the author, but the ideas are basically the same. It doesn't help, it doesn't change anything in my view. So I stopped teaching the course. And I told my students that I will teach it again when I have a philosophy that answers the questions that I was dealing with. And then I've been reflecting for some years. I've been taught jurisprudence for about 6 years now. And in that time, I've really thought deeply about it. And I could share with you some of the answers that I think about in this regard. One of them would be, actually just 3 things that I've thought about seriously. Is there such a thing as African jurisprudence? Should we use such terminology? Do we even need to have it? And I'm conscious of what Professor Ambani calls history by analogy, study by analogy. And that's what Africans have been doing, basically. You ask yourself this question: how do they do it in Oxford? This is how they do it. So can we have an African? So we are analogizing, really. We're not developing anything. And in the process, we are missing out. We are mischaracterizing, and we're just losing it altogether. And that's the danger that we fall into, even by beginning to talk about African jurisprudence. I think so. The world jurisprudence has developed in a different context altogether. And just transporting that word to Africa might not make sense at all. Although, as you will see in my second point, it makes some limited sense. Part of the truth, but not the complete truth. So I would have a problem with the word African jurisprudence as a complete rendering of the African story. It doesn't say the complete story. It says part of the story. And this is why, and that helps me maybe disclose my philosophical or theoretical position. I've been persuaded to adopt Professor Ali Mazroui's triple heritage theory. And that's the conceptual framework with which I view the world now. That the African has gone through 3 major experiences. One of them being his own tradition and culture. The second one being colonialism. And the third one being, of course, colonialism comes with Christianization, Westernization. And then the third limb or third plank is Islam and Arabization. We have some other traditions like the Asian Hinduism, but those are the 3 are the most dominant identity of the African. So if you're looking at the African, you must understand those 3 as working together in a sense. And it's hard as an African to escape any of them because of the experiences that we've gone through. So my name, for example, John Ambani, John would be a Western name and Ambani would be an African name. And the African is always a mixture. It's a mosaic of some sort, a collage of some sort, every time trying to identify himself along these 3 kinds of experiences. Having said that, the word jurisprudence then only makes sense if you think of the African in that one limited sense in which he experienced the Western world through colonialism, and it continues to this date. Unfortunately, I don't know whether I should say unfortunately, I think it is the truth. This has been the most dominant part of the African in terms of the legal realm. So when you're looking at teaching at the university, first is done in English, second is done with the viewpoints of Oxford scholars, Cambridge scholars, Yale and Harvard scholars, because that Westernization really alienated us to the point that we subordinated our own values in a sense. And I think part of what I'm committed to do in the remainder of my career is to begin to talk about the complete story, because this doesn't explain the story. I think I'll get time to talk about more. But even if we accept the term jurisprudence, then I will begin to ask harder question. Is it just jurisprudence, or we get the plural? So we start talking about jurisprudences. Is there such a word? I think I'm in England. I could get the answer. Jurisprudences, because it can't be one jurisprudence then. It could be Western jurisprudence, it could be Islamic and Arabic jurisprudence, it could be traditional African jurisprudence, because all those are our experiences. And if we're talking about traditional African, it is as diverse as you can imagine. From Ethiopia, there might be several jurisprudences there, to Cairo in Egypt, to South Africa, to Nigeria. Those are very different experiences. Could be several jurisprudences. And that debate actually echoes the one we've had in, say, religion or philosophy. Do we have one African philosophy, or do we have African philosophies? You know, you've had the likes of John Beatty, who just passed on within the last 3 weeks. That was part of the debate they had in religion, for example. And I think that would be my first submission on this point.
Well, thank you very much, John, and to all our speakers. I think now we should move on to our second question, which allows you hopefully to elaborate some of your answers to the first question. And so if I could start by asking Joel to tell us about some of the main themes in African jurisprudence.
Yeah, well, so keeping in mind the sort of historical contentions that have been posed, there are many sort of things that we do, and I would recommend as a starting point a wonderful, accessible book by John Murungi, Introduction to African Legal Philosophy is the name of that book. But there are many other writers, one of them being Mohobera Musa. I would say that the starting point of an African jurisprudence, and it's probably the feature of it that's also quite contested, is that its starting point is to blur the taken for granted distinctions between public and private, for one, legal, political, and spiritual, religious, cultural, for another, because the starting point of African jurisprudence is this philosophical anthropology of the African, which is a triadic ontological structure, right? This idea that there's a dynamic cosmological relationship between the living, the yet to be born, and the so-called living dead, imagined in the Western mind as sort of zombies and so forth. But no, we're talking here about ancestors and royal spirits in the traditions of African people. And the idea is that human life is anchored by this relationship between these three modalities of existence and these three planes of existence. So the idea that we have inherited the earth from others before us, that we are responsible to each other in very important, ethically significant ways, and that we have a world that we must leave behind for a generation to come. It's kind of the starting humanist and cultural impulse of African jurisprudence. And then I think different authors differ on sort of what are the significant pillars and so forth, but I would just list sort of many and sort of refer you to the rest of the reading. The one is, of course, the fundamental inseparability between law and morality, right? And that has to do with, as I've said, the humanistic orientation of the African tradition of jurisprudence. That's one of them. The second is that a lot of the insights of jurisprudence, of law, of how human beings should live with one another are seen as generally quite inflexible, less bureaucratically structured, but built on sort of relational networks of respect and obligation. And so African jurisprudence is in the first instance rooted in culture and custom of African people. Culture and custom as it shifts and moves, not some static fixed form of life, but an ongoing life way of African people. And that life way was, as we know, fundamentally interdicted by the colonial experience and then transformed by the colonial experience. The emphasis on restorative justice, which is, again, the idea that human beings cannot be disposed of, but can always be put in conditions of greater ethical self-perfection. Part of that being an ethical rather than a biological concept of personhood that's tied to it. A lot of the norms of the culture you find in very powerful proverbs passed down in the oral traditions of African literature. So the famous one, Molato Hauboli, right, which means an injury or a debt does not expire with the passage of time, which is a complete critique of an entirely powerful Western concept or doctrine of prescription or statute of limitations, and so on and so forth. It's the idea that problems have to be resolved so as to bring harmony on those three planes of existence: the human realm, the ancestral realm, and the realm of the yet to be born. The emphasis then being on restorative justice, on compensation, on face-to-face encounter, on community relations. And that gets more complicated when you're dealing with nation-state Westphalian big law, as it were. But I think many of those things are still possible in terms of the idea that restoring relationships is at the center of law and at the center of jurisprudence. Of course, norms of interdependence, norms of responsibility and accountability to oneself, to one's elders, to one's peers in very different ways plays an important role in how those relations are structured, right? So it's the thinking of law justice, of morality, from the cultural philosophical imagination of African culture and history as it has unfolded over the long durée of African existence. That's the one part of African jurisprudence that gives it its distinctive characteristics. It might here and there seem very much like, for example, the natural law tradition on the one hand, and it might seem very much like the Western Marxist tradition, for the Western critical tradition, because of the concern with the human and the social, rather than with the abstract or the formal. But there's, of course, another dimension to African jurisprudence, which I'll also bring up in a different context. But it is that from after the colonial encounter, the thinking on African politics and African law had to take a strong, account a strong appreciation of the afterlife of colonialism. It's linked to what John has pointed out. Although my quarrel with the triple heritage narrative, or the idea of celebrating our creolized or transcultural nature, is that some of our heritage is ours. It came to us humanly, and other parts of the heritage are violent and reproduce power dynamics, and most importantly, have produced a kind of fractured consciousness, right? These multiple heritages that you're talking about. And in South Africa, the Western African relation is not yet unified. It hasn't produced a unified consciousness. It's still produced a fractured relation. And so we need to think about how to take stock of the colonial experience. So much of African jurisprudence also now, in its particularly politicized edge, is a kind of systematic critique of Western jurisprudence, a critique of the kind of legalism, of positivism on the one hand, and a critique of the Judeo-Christian assumptions of natural law, but also a critique of the anti-religiosity or the anti-spirituality of Western critical theory as well. So part of it is this critique of the master discourses of law. And it's interesting in South Africa, just to say that because South Africa was not conquered only once, but twice, that there is an ongoing conflict between continental and analytic traditions. And that distinction also travels along the so-called historically white Afrikaans institutions and the historically white English institutions. So UCT and WITS versus UP and Stellenbosch would have very different, and in fact, the continental tradition is ensconced in places like Pretoria. But that debate, analytic continental, is a settler debate or a conqueror debate. But the real fundamental question is that African jurisprudence is yet to take its place by asserting a different cultural and philosophical standpoint.
Yeah,
I hope that just gives some of.
No, thanks, Joel, and I think we'll come back to some of those points in later questions. Ambani, do you want to add some more to Joel's?
Yeah, and I think I pretty much agree with what he said. In fact, I couldn't agree more, except just disagree with the triple heritage that we disagree, but we can come back later. We can come back later. I always thought that societies have always conquered each other within the same continent, within the same place, forcefully or otherwise. And personally, for example, I'm at peace with the triple heritage. That's why I use the name John. I had stopped doing that before. But we can go back to that conversation. But in terms of the other arguments, I think you spoke for me. I just need to add that I see two things here. One is context, and the other one is content. Because jurisprudence will always have to be in a context, I believe. If I look at, say, English or Western jurisprudence, it's hard to account for the developments, the greater developments. For example, the jurisprudence at the time or the point of Christendom is not the same as in the Enlightenment phase or post-Enlightenment phase. It accounted for the historical context of Europe at every particular time. And that makes it therefore irrelevant in the African context. So if we're talking about African jurisprudence, then it has to account for our particular experiences, which is what he said. And some of those would be slavery, for example. It has to account for colonialism. It has to account for alienation, cultural alienation. It has to account for globalization, which is coming right now and hitting Africa so hard. It has to account for a lot of such developments that we're dealing with. Neocolonialism at the moment, and stuff like that. UN politics, Security Council, and stuff like that. I think contextually, those are some of the experiences Africa goes through, and I think African jurisprudence will have to take care of that. In terms of content, I have a lot of difficulties because of the point I made earlier, which is this, that it's easy to go to the debates in Oxford, for example, between Hart and Fuller, and look for a topic there. For instance, law and morality. So the relationship between law and morality. And now you say, in the West, this is what they said the relationship is. So in Africa, this is what happens. You become guilty immediately by studying by analogy. And I've always had difficulties doing that, so I really don't know how to go about that in greater detail. But if we were to accept that we can do that, then I think that would present very interesting arguments, like you said, law versus morality. For instance, is law different from morality in the African context? Is law different from religion in the African context? That would be a fantastic debate. And you might find, for instance, that maybe there's no distinction from the gods to the state, to the law, to the norms, to culture, to tradition. They could be very much as well fused. And that's fine in an African context. If you're looking at, say, it talks about separation of public and private. You could also say, for example, separation of criminal law versus civil law. Do we have such a thing in an African setting, for example? Makes very interesting reading, I think, because if I was to say something about that, you might find that in the African traditional setting, they didn't necessarily make a difference between what was criminal and what was civil. There was probably no jail for a criminal offense, probably a fine, or probably oath, probably repentance, probably a curse, and it could take the same form in any of them. The forum would be the same, the procedure would be the same, probably, and that would present very interesting jurisprudence in terms of content. And you can go on and on and on. Otherwise, I think I would find that to be a very problematic approach. I would rather we went by the context, which then is the experiences we've gone through, and then defined jurisprudence from those contexts. I think that would make fantastic jurisprudence for Africa.
Okay, and Khomotso, if you could wrap up, please.
Okay. That's a hard act to follow. I suppose I'll just pick up on two things here about distinct themes. And linked to what I said earlier, I think it should come as no surprise that in African jurisprudence, one great theme is the ethical conception of personhood, as Joel mentioned. And I think it would be self-explanatory to understand why personhood in particular mattered, particularly for the post-colonial African scholars who are trying to explore what exactly is a basic definition of being a human being and what human beings owe to each other, and particularly the status question, obviously because of colonialism's denial of African personhood per se, or rather, let me just say not denial, maybe skepticism around whether Africans were fully human in certain respects. And so you needed a clear articulation of what it would mean to be a human being, and also how to become a human being in a certain respect. And so this goes back to my earlier point about the priority of certain questions, I think being strangely, uniquely African, and linked to John's earlier point about context. I think it's self-explanatory why contextually these are the priority of questions we care about. Now, following from this emerged, I think, an attempt, I think, as I said, to give an account of what are the properties of personhood per se in order to start talking about legal obligations or moral obligations more generally, and then seeing how these are articulated in law. However, I'll give an example based in a South African context about some of the mistakes made, I think, in my view, in exploring some of these problems, and where I think there was a sharp turn or a dead-end turn, certainly in South African jurisprudence. So maybe, Joel, you might agree or disagree. Let's see. Namely, I think the preoccupation probably articulated with Ubuntu, or by the Ubuntu discourse in South Africa, has been strangely confused and conflated, and I believe promiscuously used generally, as sort of I think a gesturing point about basic humanity, but not really paying proper attention to the metaphysical propositions that African scholars were actually concentrating on, namely this ethical conception of personhood, and that one may certainly be born a person, I suppose, to some degree, or a human being, but how do you become a proper, well-functioning person in the full sense of the word? Or even, as Menkiti himself expressed some doubt, how do you become a person in the first place? Just simply because you are born human does not necessarily mean that you are fully a moral person, as understood. And these questions, I think, ran much more deeper and were much more radical than some people understood them to be, I think, when they were trying to tackle this particular question of Ubuntu in the South African context. Ubuntu, as you know, is something like I am who I am through other people. It's a particular sort of South African saying, but I think Southern African maybe might be more correct to say. And from this, I say this quite aware of the South African Constitutional Court's position on this, but from this was an attempt, I think, to explicate a dignity jurisprudence. And what we saw from that is actually linked to, I think, maybe something that is unique to African jurisprudence, which is the assumption of the very close link between law, morality, and metaphysical questions being interlocked together if you are going to give a proper legal theory of a particular question that African jurisprudence would prioritize. So if you're going to think about dignity, you can't displace dignity simply as a Kantian proposition in the abstract. You need to properly articulate what we mean when we say particularly personhood in an African context and obligations flowing from personhood itself. So that's just one example of, I think, some of the themes and how they are relevant, particularly in a legal discourse, and certainly in a more concrete way, seeing how not understanding context in particular and not understanding particularly the initial philosophical debates makes for bad jurisprudence, at least down the line. Or certainly we can say bad African jurisprudence if we're going to say that such a thing exists. Yeah.
Well, because Ubuntu is such a prominent conception, Joel, do you want to come back on any of that before we move on to the next question?
Yeah, I'll say, I mean, that as I've taught Ubuntu thought, Ubuntu philosophy and African philosophy in law, I do make a strong distinction between the version that was developed by the Constitutional Court. In at least, as Khomotso says, a philosophically unrigorous way in the first instance, but also a very politically dubious way. Ubuntu emerged in the early 90s as a very particular device for dealing with the contradictions of the transition, and increasingly is seen by many as an instrument of pacification, and just clumsily formulated and often fairly, it's like Ubuntu is used as African spice, you know, on an otherwise Western dish. I don't like that formulation, but of course it's not the job of judges to do philosophical work. It may be their job to be true to the philosophy that they are drawing on. But then I would insist there's another conception, which is a fairly radical conception of Ubuntu, which would in fact be in opposition to the both the cultural and political premises of the South African Constitution, and really of Western law as such. And that's the point you're pointing out about some of its deeper metaphysical and philosophical implications. I spoke about Mulato Aubole as a fundamental principle, the idea that a debt or a feud, and in this instance a historical injustice, cannot be erased, passed over, or not fully confronted. It has to be dealt with at the concrete level, not simply at the formal level, before you could speak of justice in any sense. So yes, I think there is in South African legal and political thought many Ubuntus, to put it that way. But I would say there's a contention, a very powerful contention between the version that emerged out of the Constitutional Court and out of some of the extra-curial writings of people like Judge Yvonne Mokgoro and others, as well as its uptake by American scholars of all stripes. Let's call that constitutional Ubuntu. And then one that has been developed by African philosophers, who many of whom, interestingly, were not cited or relied upon in the making of constitutional Ubuntu. Let's call that African Ubuntu, or the Ubuntu of Abatu, Abantu or of Batu. I think there are some serious tensions there. And the major tension for me in relation to Ubuntu in South Africa today is that one is seen as reconcilable with the constitutional project, and another is completely antithetical to it.
Okay, so I can see that we're coming up to some of your published work on this topic. So hopefully you'll have the chance to develop some of those themes in relation to the later questions. But Ambani, was there anything that you wanted to add on the concept of Ubuntu specifically?
No.
Okay.
I think South Africans are the experts for that. but we have it. It's called Utu.
Of course,
It's an African concept. It's not South African, but I'm saying as developed, say, in the courts, that's the South African touch. But as Ubuntu, Utu, that we have as well.
That's right.
Yeah.
That's fair.
All right, thank you. So moving on to our next question about how, if at all, is jurisprudence by Western philosophers such as Hart and Dworkin relevant to countries in Africa? Ambani, can you start on that question?
Yeah, I think the question is already answered based on what we have already said. But allow me to just say, maybe use two illustrations to say what I want to say. One is a case recently in Kenya. It's called the Abdo case. Abdo. There's a criminal case, a murder case in a magistrate court. And in between, or in the course of the litigation, the prosecutor comes and tells the judge, the parties have settled the matter. They're from the Somali community. There's a way they handle those cases. They exchange probably camels. The society repents. They agree. They take an oath. The matter is finished. And they come to court and say, we've done that already. So, and because of the oath, we can never continue with this conversation. We shall receive a curse. And the judicial officer decides to terminate the case and says, yes, I agree. You've entered a decision mediated between yourselves, and you're happy. So the case can drop out. And it brought a lot of conversation among legal scholars about whether a criminal case can be decided out of court in a cultural way. It's an interesting case, but it tells you something that people have been running away from, that there's another law. There's another law. What tended to happen in most of Africa was when the black elites took over the reins of power, as black as they were, they simply continued the colonial heritage. So as the captains of the state, our thinking is westernized. Nearly all pioneer leaders in Africa, whether it be it in the judiciary or the executive or parliament, had been trained these sides. When they came to take over, they just thought this is the way to go. And so they emphasized the formal, I'm using the word formal because that's what the state has adopted, the formal law, the formal jurisprudence. And that has become what then guides the nation. But they do so notwithstanding a significant part of the population that still practices another law. And always there's a conflict between the two dispensations. The ones in power, which the state has adopted, the westernized law, which is, I said, one plank of the triple heritage, and the other two or three, depending on which country you're talking about. And so that explains the problem. And so if you're thinking about Hart or Dworkin in the context of this formal law adopted by the state, and which continues to be the dominant one formally, then you're right, Hart has relevance in Africa. And a lot of relevance, because as black judges, as black scholars, we simply cut and paste what's happening in Oxford and take it to Nairobi, take it to Johannesburg, to Pretoria, you know. But if you want to be a good academic or a good jurisprudent, a good judge, then you must go deeper and ask yourself, is this law applicable to everyone else? And you'll find, no, people don't believe in that law. Just part of the explanation. We go back to the triple heritage then, that there are other parts of the law, there are other parts of the legal system that this Hart cannot explain. Yeah, that Dworkin can never explain, not on any single day. And you want to ask yourself, when Dworkin was writing, or Hart was writing, what was he thinking about? Was he thinking about the nomadic pastoralist in Kenya, northern Kenya? Was he thinking about that? Did he have them in mind or in contemplation? I'm sure not. So obviously his ideas cannot address or cannot account for their problems, at least as a legal system, as the people as a legal system. And that then, therein lies my answer, that the story is a third of the truth. There are other 2/3 that the jurisprudence of Hart can never address. And that is where we must go. And so later I think we shall get time to talk about, say, decolonizing, so that we can begin to see what is happening, this mosaic, because one has dominated others unfairly, and we need to undo that.
Okay, thank you. Khomotso, without repeating what's been said, is there anything you want to add?
Yeah. So I'm quite comfortable teaching Hart and Dworkin, etc., in a jurisprudence course in an African university, but I care deeply about how one teaches Hart and Dworkin, etc., and the care that needs to be taken, once again, to properly contextualize these sources. I'm also very comfortable with trying to theorize about particular problems that formal law has in an African context, per se, and new challenges around how we think about intellectual property law, for instance, and rights of indigenous communities, or about certain problems in criminal law, where I think sometimes we place heavy emphasis on restorative justice in a particular instance, where I think that there is strong justification in the African sense for retributive justice. Thank you very much. As a criminal lawyer, I care very deeply about that question. And so I have no particular problem doing my best not to commit a fallacy about genetic origins, or simply saying because the source itself is Western, therefore I reject it. But certainly that does mean a proper rigorous curriculum must understand the context of Hart's project and of Dworkin's project. And so I'll say two controversial things then, criticizing how jurisprudence is taught, particularly in South Africa, and then also how I think some judges view jurisprudence. I think there are always two kinds of really bad judgments that come out of African courts generally when they're dealing with some kind of Western basis of an analytical theory or a continental theory. I don't really care which one. But in the legal sense, what I've noticed is usually either one, some very bad positivism that comes out, which is something like people who've clearly thought that, certainly in the South African context, a new constitution was passed and therefore is a moral legal code that is comprehensive, complete, and from that, all things must be anchored and emanate from it. So entirely an argument from authority that I find particularly, one, boring, and then two, just unrigorous, because of course any serious person who understood Hart's project could never think that that was good positivism by any measure. I think Hart himself would be horrified by that kind of approach. The second is some very bad Dworkinianism as well. And it's linked particularly in this instance, not to the authority of a constitutional text, but its complete comprehensiveness. There are some judges who write, or lawyers or theorists who write about particularly a South African constitution, but constitutions, post-colonial constitutions, as though this really were a comprehensive moral theory, not just simply a legal document to be reasoned in a legal system, and unique problems and challenges in the African context that may present themselves, but certainly as though, questions about free will or responsibility and agency somehow can be answered if we all just got back to the Constitution and understood all its wonderful values in some sense, which I think is just bad Dworkinianism in a very serious sense. And then this results, I'll end off here, with some very, very badly reasoned judgments, where what you see, particularly in the South African Constitutional Court, is this gesturing towards values, and then suddenly we arrive at conclusions. But somehow it seems as though the South African public no longer deserves reasons and explanations at a particularly expected, rigorous standard. And I think part of this must be a particular bad Dworkinianism and a particular bad positivism in one form or the other that does not place proper context and real sophisticated understanding of some of the developments in Western jurisprudence, and also, of course, the absolute neglect of African jurisprudence actually having its voice and say in the reasoning of courts and the reasoning of certain legal theorists. Yeah.
And finally on this question, Joel.
Thank you. I agree, but I think from a whole other side with Khomotso about the problem in South Africa of constitutional worship, which is what I derisively call it, but also constitutional optimism. I was also just going to tease you and say, isn't bad optimism like bad positivism, like a tautology? But we can take that up on another day. Edward Said posed this question many years ago: can theory travel? And this is the question that John has answered. Whatever ideas you bring into a space, you have to contextualize, but you've also got to read them critically and think about what was the initial milieu in which the theorist or the theory developed, and what is the context in which you want to use it. So far, there's been an unreflective relationship with Western thought in the South African Academy and perhaps everywhere else. So we first need to think about that. I do think there's some of the problems and questions of Western jurisprudence can just be shoved out from our context. But the ones that can be kept, can be reconstructed, and can be productively used to answer our questions and problems should be used. And there's nothing in the politics or discourse of decolonization or of Africanization that is simply about a complete throwing away, as it were, of Western thought, given that the genealogy of what is called Western itself is a matter of serious contention. So that's the first point. Anton Lembede, the father of Africanism in South Africa, or at least its chief progenitor in the mid-20th century, drew this distinction between being assimilated and being borrowed, and you doing the borrowing and assimilating on your own terms. So I'm quite happy to see an African reading of Hart, or an African reading of Fuller, or Rawls, or Nozick, or Marx, if it's grounded to those material conditions. I mean, there's also a debate about what people call the two Europes, right? The sort of conservative, classical, Eurocentric Europe, but also those traditions of European thought that became instrumental in anti-colonial struggle. Marxism is one obvious particular one, but I would think that in the making of post-colonial democracy, so did certain kinds of liberalism become useful when remodeled for the particular context. But it's telling that Rawls himself didn't think about race, not only colonialism outside, and at least in a theory of justice, was not even thinking seriously about race in the United States at the time he was writing, right? There's a deep debate among Black Rawlsians about the status of race in his writings, and the complete inability to think slavery as a founding problem of politics and a founding problem of the social. So that's the one part of the answer. But the second part of the answer is that part of what we should be doing in jurisprudence, I know that's going to answer a question to come, but is that we've got to be doing intellectual history. So Hart and Fuller and those debates are partly important to map out for students what the kinds of issues were, even if in the end we're going to show how those debates were tied to the epistemic racism and Eurocentrism of the academy and of South African society at the time. It is important for them to see how different ideas shifted and the role that was played. In the major jurisprudential debates in South Africa, and I always have to say this when I'm in other parts of the world, have simply been a family squabble between different traditions of white thought. We're trying to break that completely, and part of that problem boils down to the South African Constitution, which is always a matter for another day for me. But so absolutely, I think there's lots of room for Western jurisprudence in an African context, if appropriately and critically taught. It has to be remembered that some of these founding thinkers were, I mean, apart from holding atrocious views, but were instrumentalized in very particular ways in the upholding of the colonial and imperial systems in Africa. So that has to be part of the conversation. if they are to be taught. But I would also say that we do need to go past the time when the disproportionate emphasis is on Western jurisprudence. Right?
All right, I think we're agreed on that. So moving on to unpack some of what is African jurisprudence. Joel, can you start us with the question of the forms, methodologies, and styles of African jurisprudence, both as it appears in the global north, so in Europe and North America, and in the global south?
Sure. So I think it's important that, and we know this, that many African intellectuals from the first generation of literate Africans right up until now are Western trained and Western socialized. So this isn't about any kind of purity. These are people who've been trained, but who are resisting some of the tyranny of Western paradigms in their thinking. So I think there are many questions that face African jurisprudence. And firstly, I think African jurisprudence should be taught everywhere, including in the hallowed halls of Oxford, and perhaps not including, but more importantly, in the hallowed halls of places like here. But I would say there are three major priorities or three major lines of inquiry or major questions for African jurisprudence that have been really mainstays for a long time. The first one I've pointed out is that there has to be a kind of systematic critique, sometimes even negation, sometimes reconstruction, reworking, challenging and resisting of the paradigms and categories of Western law and Western jurisprudence. So let's call that project the critical negative project of African jurisprudence is the first major question. The kind of, I don't want to use the word deconstruction because of its other European life, but there has to be some kind of fundamental reworking critique of the ideas that have been inherited from the Western canon, partly to show that they are also fallible and questionable like all other ideas, but partly also to do that work of grounding them in context and also being able to make evaluations and judgments about what can stay and what should go. That requires you to do a proper, thorough study and then deconstruction of the Western archive. The second thing I think has to do with what we call decolonization, but part of the project of an African jurisprudence has to be the recovery of African history, experience, and culture in the thinking of law. And that part of the project, of course, has to be looking at how those proverbs and those archives and those oral and written histories can be used to develop and build on ideas of an African jurisprudence. And this means going beyond the realm of law and legal academics, and it even means going beyond the realm of the university to think about how intellectuals, African intellectuals who were not in the university or who were not primarily producing work to teach. I mean, you've mentioned, I've mentioned people like Ali Mazrui, I've done work on Steve Biko, and there's much more work to be done there. There's much more work to be done on the traditions of the African prophets and warrior chiefs, from which you can develop insights for different ideas of law, including different critical but different classical ideas. So that's the second thing, recovering. That's the decolonization part, the recovery of an African episteme. Then the third one is that African jurisprudence has to be part of and take the lead in the task of addressing the socio-political and socio-economic realities of the African continent on two levels. The obvious ones being the afterlives of colonialism and apartheid. Poverty, unemployment, inequality, social divisions, and so on and so forth. There has to be some way of resolving and thinking about those in a very concrete way. The second one is having to think about the questions that John and Khomotso have pointed out, questions of stability, questions of interpretations, questions of the structure of the state, the modes of political organization. African jurisprudence has to speak to that. So I see these three projects sort of happening all at once, the critique of the Western archive, the recovery of an African archive, but also the concrete engagement with the present reality of Africans. And the major thing is that combines the problems of the African reality is this problem of neocolonialism and the problems of, so questions around democracy, questions around the sort of political challenges of building post-colonial nationhood. That's part, I would say, of the agendas and of African jurisprudence. So I would insist that African jurisprudence should maintain its political and morally open-ended nature rather than an abstract or technical form, if that makes sense.
Yeah, thanks. Khomotso.
I think I'm going to disagree a little bit fundamentally, because I think that there's a real serious need for very, very deep reflective conceptual work that whilst I think the socio-political movements of our times and of our past have heavily influenced and I think enriched African philosophy, jurisprudence, and thought, I often think that there's a real neglect for proper conceptual work being done in African jurisprudence. And I'll use a few examples and hopefully make myself clearer in doing so. So the first would be, I think there needs to be what Kwasi Wiredu called pursuit of the universal through the particular, right? So everything I've been talking about context in a particularly important sense of, all right, we understand that there are certain questions in African philosophy and African jurisprudence that have priority. However, we're not pursuing these questions simply, only, and I suppose because Africans care about them. These are universal questions. These are universal propositions. Personhood is a universal moral problem. There are perhaps unique African perspectives on this, but our pursuit, our ambitions, in a certain way, I'm going to quite tongue-in-cheek say, ought to be imperial. They ought to be saying something that we think and believe is true for all time and now, and hopefully, as a moral realist, certainly was true in the past. So I do think that that is one particular project that must be adopted. The second is theorizing about specific areas of law. I don't mean necessarily the traditional divide of public and private, etc., but I taught, for instance, property law at the University of Cape Town, and there is a great dearth of trying to understand African customary property systems at the conceptual level. What particular conceptual structures do the relationships that several African communities have, which are very sophisticated, and sophisticated accounts of what property interests one can have, etc., that I think have been heavily neglected by theorists, and particularly by African theorists, understandably because our problems have been on a much grander scale, neocolonialism, etc. But I do think that there is virtue in pursuing particular theorization of specific areas of law, if we're going to talk about African jurisprudence and its methodologies, etc. And then the last bit is the particular problem if we're going to talk about specific political questions and socio-economic questions, etc. I do think that African jurisprudence must at least address serious questions of agency and responsibility and how we conceptualize that in the context that we find ourselves. So, for instance, I mean, as a criminal lawyer, the obvious tension exists about how do we hold people criminally responsible born in a neo-colonial context and really in the worst economic conditions one can imagine. This is a problem, of course, globally, generally, but I think that it's even more pressing, particularly in Africa. And these are serious moral challenges. Now, I happen to believe, by the way, that we can hold people morally responsible despite this. But that particular position requires serious justification and is a huge challenge. And so I would happily accept Joel's challenge on that problem, but I'd identify particularly the problem of agency and responsibility as well as a huge question that's very dense, but that cannot be ignored in African jurisprudence. Yeah.
Okay. Okay, I think I'm the one naturally because I'm the last one. Just again, two illustrations, some stories that I come across in my country, especially in the course of teaching. One of them is in the law of torts. Torts is still taught in my country the same way it's taught here, the same sources. I believe more than 100%, just as it's taught here. And I think there's a case in Tots called what? Cassidy or something? I think there's a picture of a man and a woman, and the insinuation is that they're married and they are not man and wife, and so that is defamation or something. And you find an African judge in an African country meeting the same circumstances and pronouncing it that way in 1960s, 70s, in a society where having more women as wives didn't matter. It wasn't bad. You can marry 5 women so long as you can take care of them. So at what point are you defamed by appearing in a photo with a woman? Do you understand what I'm talking about? Or is someone defamed by being called a cow? Ngombe. Ngombe is the name for a cow where I come from. If you called me cow, in some communities, you're actually glorifying me because cows are regarded highly, especially in nomadic communities. So you find a judge thinking that is defamation because he's thinking like in the Cassidy sense. Do you understand what I'm talking about? So when you find those decisions, you clearly see that we have a difficult task as people who are thinking about decolonizing, because we are really colonized, like he said. And so I look at African jurisprudence. Remember, I'm against the word African jurisprudence. I'm just using it for the sake of this conversation. But if we were to do African jurisprudence, the first task, I think, would be one of social engineering. You have to decolonize the actors. You have to tell them that things are not the way you were told. They are actually very different. And actually you could think in a different way. So it's a sociology, it's a psychology, it's a lot of process that is going on here. But fundamentally, first and foremost, it's a sensitization process to change the mindset so that people can look at things the other way. If you came to African universities, you'll find that course outlines are 80-90% foreign, Western in particular. And you must begin to tell the teachers that it doesn't always have to be that way. Sometimes I've told teachers to change the curriculum. I happen to mentor many of them. Introduce African writers, and they say, what will happen if our students graduate and they've never heard of, for example, Hart or Fuller? Then I usually ask one basic question. Are the people in Oxford learning about Beatty? Are they learning about him? Mm. Yeah. So if they're not bothered about learning about you, don't bother learning about them. Okay? Students can learn that later, but in class, make sure they understand their context. You need a lot of that, telling them that you don't lose anything by studying African scholars. Yes, you have to learn everything. You have to learn as much as we can, but we must focus on our own writers that are context-specific. But again, I already mentioned that some of the writers we have are black only to the extent of color, but they're still writing Western stuff. And I think you must be conscious of that. Mm. So that pedagogy, apart from being a social engineering process, must capture the context. I think I already said that. And he mentioned that already. Colonialism, post-colonialism, that's what we're dealing with now. And now, as we are still shaking, we are meeting globalization, complete with all its ills, and still unstable in conflict and all that. We must begin to contextualize that and provide frameworks that can explain that, frameworks that can find solutions to those problems. I think that African jurisprudence will always and must be multidisciplinary. In fact, we're difficult with this concept because there's a lot of African jurisprudence out there, but you won't find it in a law book. Not always. African jurisprudence will be found. For me, the most, the biggest archives for African jurisprudence will be in literature books. If you'd read the writings of, say, Ngugi wa Thiong'o, if you'd read the writings of Chinua Achebe, L.H. Amadi, you will see a lot of African jurisprudence of the colonial epoch and its impact on Africa. Post-colonialism, how modern governments have struggled to deal with the ills of colonialism. For example, a divided society, ethnic divisions and stuff like that. Conflict and violence, transition, all that is in literature. You will see it in religion. And I can recommend John Beatty's book, African Traditional Religion. Just look at it and you'll get all these answers. I can recommend political books like Triple Heritage. You will see this kind of dynamics coming out of them. So African jurisprudence, if we accept that word, then we'll have to be very multidisciplinary, taking care of all those disciplines and teaching them, as if They are the curriculum. Remember the distinction of disciplines, saying this is one discipline and this is the other, and that when we are learning this, we don't learn that, could also very much be a Western concept. And the Africans cannot ignore their politics. They cannot ignore their history, because it's their history that gives us the context. And I think that answers the last point I had, that actually it must be context specific. It must be context specific and context sensitive if we are going to teach it. We had talked about Kiswahili because of language, because being forced to say jurisprudence, we are just missing it. By speaking in English, we're actually missing the point. And I think at some point, that conversation must be had. In what language must we teach African philosophy to our students in Africa? I think that conversation needs to be had. The issue of language and how a lot is lost in trying to translate language to a different context that wasn't contemplated when the language was designed. Thank you very much.
Thank you, Ambani. I think that combines your answers to how jurisprudence should be taught, as well as what are the styles of present jurisprudence. So thanks for that. Joel, do you want to jump in on this point?
Two things. Let me start by responding to Khomotso, and just by laying out the distinctions are just so. Maybe let me start with the simple one. I don't see the intricate doctrinal problems of everyday law in terms of their impact on human beings to be separated from the larger problems of neocolonialism. So in other words, I think the everyday doctrinal problems of everyday law are depend upon these larger concepts that need to be reworked at a fairly large level. That maybe is the first point. The second point for me is, I guess so I completely disagree about a pure universalism, about accounts that are true for all time. I don't believe in accounts from nowhere, and I certainly don't believe in accounts that outlast the context and lives that constituted them. I come from that situated, constructed truths that become hegemonic because of the political, social, moral contexts, but are always open to questioning and, in fact, complete remaking in the world. So I guess I differ with that. And we've got the most dramatic but also perverse attempt to build the universal through the particular was, of course, colonization, right? That's the best example. All universals are particulars, right? So that's also that's linked to my point that the problem for me with Kwasi Virodi, but also with John Beatty. I mean, John Beatty, wonderful book. I also recommend that people should get it, African Religions and Philosophies. But essentially, his fundamental conclusion is that African spirituality must exist under the tutelage of Christianity. So, and the reason I'm only mentioning that is not because I'm trying to point out that he's not woke or anything like that. What I want to say is, I expect that when we bring in African and Black thinkers into the curriculum, that they will also be subjected to critical scrutiny and be read with the integrity of an intellectual. So we're not saying just add Africans and then worship the readings. No, we will see flaws in Beatty, in Viredu, in Ramos, and so on and so forth. That rightly so, because great minds have flaws, actually. That's part of being a great mind. So I guess that's perhaps where I would sort of differ. I would also worry that if one simply says, and this is happening in South Africa, decolonizing criminal law or decolonizing, banking law, already accepts that conceptual structure and classification of systems of law. Already accepts that there will be something called criminal law. So in other words, that in an African schematic of law, it already imports that category. So I'm almost taking a step back from that assumption. It's the same as like prisons. I was just reading a paper on decolonizing prisons, and I would think, well, maybe in a decolonized society there wouldn't be prisons. So to already do that is it's actually bad conceptual work, because it presumes the conceptual structure rather than interrogate it. So that's the only reason why I wouldn't start there. I agree that one needs to get into the nitty-gritty of everyday law, but I'd be worried if part of that means to accept that conceptual structure and classificatory structure already, right? That there will always be criminal law, particularly the public-private divide, for example, right, would be an obvious one. So I would say that too must be subjected to this larger, more concrete conceptual work. Yeah, I'll leave it there. I wanted to say a few things more about John Beatty's Christian imperialism, and that's just because I think it's important that African philosophers also be given the respect of being challenged about some of their assumptions. I was horrified about the way Mbiti believes that African spirituality, inherent immaturity, is to be resolved by its embrace of the Christian ethic. And that's because he was an Anglican priest, I think. I was just in Canterbury in Kent, so it's part of that. Yeah. So I think there are, at some point, the clarity of, or rather let me put it this way. I expect that a decolonized curriculum will also be approached as critically as a colonial curriculum. I want to put it there.
All right, so that will lead us very nicely on to our last question about teaching jurisprudence. Can you very briefly, in 2 minutes, and I'm sorry, I know you've published a lot on this, so if people are interested, they can go to Joel's published work. Can you summarize your prescriptions for teaching jurisprudence?
Sure, I have no prescriptions. I will say something. I've just been. I just listened to American political theorist Wendy Brown's lectures on her Tanner lectures on human values. She makes this interesting claim about the idea that the scholar teacher is a disunified subject. So, in other words, as a scholar, I would immediately say that in South Africa there has to be a discussion about race, class, and gender. That in South Africa, there has to be a complete overhaul of the jurisprudential archive with reference to Black and African thinkers. That as a scholar, I would say that the approach should be a critical one, should be centered on outcomes rather than, in other words, it shouldn't be about the sort of pristine logic of law. It should be about law's impact on the social. But then the teacher in me would say something else. So in other words, I think that we need to reflect on a few things. One, we need to reflect on the distinction between, in a way, training students and molding students. So training students is about giving them particular capacities, critical thinking, the ability to provide an explanation, and worldliness and thoughtfulness, which has to be part of how we teach our students. And then molding is shaping their actual views. And I actually think we need to be spending more time training students to develop high-level conceptual and analytical capacities before always thinking about shaping their views. Now that's contentious because there's still the myth in South Africa that formalistic teaching is without a politics, and that critical teaching is the political one. And I think you obviously have to demolish that set of assumptions. So actually, that's where I would leave it. I would insist that as teachers we reflect on the disunity between our scholarly priorities, which are important, and our responsibility as teachers, which includes exposure of ourselves and our students to uncomfortable and even boring materials. Because I also get a sense of something else, which is that we now are dealing with a new world, or a world in serious turbulence. We've got to think about how certain global ruptures and risks, among other things, the complete collapse of the liberal democratic ideal in the West, and what it has produced by way of what we now see globally as the rise of the right wing, among other things, but also the complete nihilism that comes with knowledge and politics today. That's going to require us to do a little bit more training in the capacity to think for a future, versus always already molding a view. Something I've been thinking about. Yeah.
It's very interesting. Khomotso, could you wrap up the discussion, and then we'll open the floor to questions, just on the teaching of jurisprudence in the global north and global south?
As has been the theme, I will be disagreeing and agreeing with Joel for different reasons. Certainly, I think, to return to the point about teaching specific areas of law, I'm very happy to be critical of the categories that already exist, but I am one of those people who believes a system comprises of its parts as well. And so inevitably there'll be new categories, which I'm happy to form, but I do think even at that fine grade level, we'll need to think seriously about it in an African jurisprudence. Regardless, as for my particular view about a proper teaching methodology, So as a so-called radical right-winger, as I've been branded in my old institution, disclosure, it doesn't take much to be right-wing in UCT. Just, I think even you would be called conservative there these days. But as a so-called right-winger, I'll quote the controversial feminist author Camille Paglia when she was asked this question about a proper arts curriculum, and I thought she said some very important things about that. The first is, I think we need to return to the idea of a grand sort of survey course in a serious way. I know that at the University of Pretoria, there was an attempt to do that with what you called jurisprudence, I suppose. But at a serious level, there needs to be a proper ability of law students to connect conceptual development across time and history, whilst being aware of the specific contextual forces that led to the concepts themselves existing. So Paglia, for instance, in her arts course, starts from the Stone Age and then works through to various movements and currently even to global movements in the art world. And you spend a year just doing that survey kind of work, because the biggest problem law students are facing now is connecting concepts. I think across the board globally, but particularly I think it is irresponsible in an African context to produce students who cannot do this. And then the last point will be a very, very important point, which is a proper African jurisprudence will be difficult. It will be hard for students to learn and master. It is not easy because it is doing a lot of conceptual heavy lifting. It is reading intensive. It will demand a lot. And so there's a real ethical challenge about what teachers can expect of students. I believe in a high standards, low stakes kind of approach about what kinds of evaluations count for what, etc., and how you build that kind of knowledge in a curriculum. But I do think that's an important question, that there must be this rejection of this idea that a decolonized curriculum is going to be easy. And it's going to be easy for students to do and to learn. No, it's more work, in fact, and that's a good thing. Yeah.
All right, well, that's a wonderful point to end the formal part of the panel on.